Hello friends, welcome to GST capsules. I am your friend for this particular video. My name is A. Vikram Kataria. So in this particular video we are going to look at some of the critical changes which have been introduced with regard to the registration process and the provisions with regard to suspension and cancellation of registration. So as many of you would have been aware that notification number 94/2020 Central Tax has been issued on 22nd December 2020, wherein certain key changes have been introduced in the CGST rules, which could actually have lot of implications for the industry at large. So in general, in any taxation law, the thought process of the government should be in a way that it is a trust-based law and the compliance mechanism which is created, wherein it is a case where a selected few are chosen for the purpose of assessments or audits. A slightly larger group would be subjected to scrutiny of the data furnished by them basis the details available with the department, and the notices are issued to them to provide valid responses, and then the government or the department can satisfy themselves with regard to the compliance levels of such assessees. So in general, the approach should have been a trust-based approach and not a skeptical-based approach, wherein the ideology under a skeptical-based taxing law is that the department is always wearing a skeptical lens and viewing every taxpayer in a way that the assumption is that there is certainly going to be a non-compliance or an offense which is going to be committed by the said taxpayer intentionally with the objective of defrauding the revenue. So the changes brought about under this particular notification is possibly giving an indication that slowly the government is actually losing trust on the taxpayers, but it is not a case where all the taxpayers are non-compliant or committing serious offences. It is a selected group of people who have committed serious offences, but the changes brought about in the CGST rules will actually impact majority of the business players, and accordingly the challenges will arise. So when we look at the changes, so when I go back to March 2020, where the registration process was actually simplified. So wherein the government introduced a system of doing an Aadhaar authentication while filing your registration application. So if a business who wants to take a registration, while filing the registration application also does the Aadhaar authentication, then the registration to that particular person is granted within a period of 3 days. So the thought process was to move towards a system where the registration process is simplified and moving towards, as we call, ease of doing business in India. So one of the major steps towards that was to ease the process of obtaining the registration. But considering the recent news of bill tradings happening, bogus registrations being taken, now they are actually going little further and making the registration process little more stringent. So that is where in Rule 8, this Rule 4A has been substituted with a specific rule. But one point to be noted here is that in general this entire notification will be applicable from the date of this notification being published in the official gazette. But specifically for Rule 8, there has been a provision which has been inserted in the notification that this particular rule will be notified at a future date by a separate notification. So the kind of amendments which are proposed in Rule 8, what I am going to cover now, are not applicable straight away. They will be applicable from a date which is notified by a separate notification. So please be aware of the process. Once it is implemented, that will be the process of filing the application for registration. So this sub-rule 4A of Rule 8 has brought in a process of biometric based verification of Aadhaar, as well as a process of taking a photograph. So earlier it was more of an OTP which was sent to the mobile number of the Aadhaar, the person who holds the Aadhaar. But now the system of biometric based Aadhaar authentication, as well as taking a photograph of the person, so that particular process has been introduced. Or if the person does not have an Aadhaar, then the details of the biometric has to be provided, the KYC documents has to be verified, and both these processes, whether it's a biometric verification of Aadhaar or a biometric punch or verifying the KYC documents, have to be done at the facilitation centers. But those facilitation centers have to be established, and that also the particular amendment provides that the government would set up facilitation centers for this particular process. Now, if a person has to go through the entire process of validation or verification of his biometric, verification of KYC documents at a facilitation center, then the said person has to go to the facilitation center, and that is going to increase the time for filing the application itself. So earlier, where the application was all done offline, now there is some requirement of a person visiting to the facilitation center to do the verification of Aadhaar or doing the biometric submission and verification of KYC. So this is again going to increase the time for filing of application. Moving ahead, this is just the first step, which is filing of application. There has also been changes in Rule 9, which is verification and grant of registration. So here the original provision which existed prior to this notification was that once an application is filed and Aadhaar verification is done, which was in terms of an OTP, registration was granted within 3 days. So now they have increased the time limit from 3 days to 7 days, where the provisions of Rule 4A, Sub-Rule 4A of Rule 8 has been complied. So which means the verification at the facilitation center has been done. But now the question here is, Rule 8 Sub-Rule 4A, though it is provided in the notification, it is not yet effective. So when that particular process is not effective, the changes brought in Rule 9, will that also be postponed to a future date, or it is something which is going to be applicable from the date of the notification? So here the point of view is that when a particular procedure which has been deferred and which is not applicable today, then the time limit which is linked to the procedure which is deferred also will be deferred. So technically, till the time the new Sub-Rule 4A is not implemented, the officer should actually grant the registrations within 3 days of the application being filed if the Aadhaar authentication as done prior to this notification is complied with. In the same rule, Rule 9 Sub-Rule 1, there is a proviso, and even that proviso has been amended. That proviso actually provides for a case of the premises of the registered person being physically inspected by the officer. So earlier it was only a case where a person who was not opted for Aadhaar authentication would be subjected to this physical verification. But now, in addition to this category of people who have not done the Aadhaar authentication, the assistant commissioner, any officer not below the rank of assistant commissioner, will also have powers to select those people who have applied for registration where he feels that the verification of premises would be required. So it is not a case of a default provision where once I have done the Aadhaar authentication, I am assured of getting a registration within a revised date of 7 days. But under this particular proviso, if the assistant commissioner selects my file where I have filed the application for registration, then my application will be subjected to on-site verification of the business premises by the department officer, and the time which is given to grant the registration for such class of assessees is increased to 30 days. So in summary, if I have complied with the requirement of Sub-Rule 4A of Rule 8, which requires the biometric authentication or submission of biometric data with KYC documents, then my registration in a normal scenario should be granted in 7 days. However, if my application is mapped as one of those applications where physical inspection is required, then my time increases to 30 days to get the registration. So again, by these amendments, certainly the time which is required for obtaining a registration under GST is going to increase substantially, and certainly it is more a case where the skeptical lens of the department is going to drive the registration process, and maybe majority of the applications could be subjected to on-site verification. So again, are we looking at some kind of a tax terrorism where the officers would visit the on-site premise of the assessee, and that could actually lead to delay in getting the registration granted? So similarly, Rule 9 also had a provision for issuance of notice where there are certain discrepancies in the application filed by the person who is seeking for the registration. So even here, the earlier time for a person who has done the Aadhaar authentication was 3 days, which is now increased to 7 days. For all other cases, it has also increased to 30 days for issuance of notice, and the applicant is given 7 days time to reply to the said notice. So all these put together, one conclusion which can be drawn is that the registration process, which generally should be a simplified process, is now going to become a cumbersome process, wherein the challenges of a person going to the facilitation center to do the Aadhaar authentication or verification of KYC documents, that is one compliance burden. The second challenge is, even if I do the said requirement of sub-rule 4A of Rule 8, I may still be subjected to on-site verification, which further delays my registration process. So slowly we are moving from a regime of trust-based registration to a regime of skeptical view by the department. So this is the changes with regard to Rule 8 and Rule 9 for filing of application and the process of grant of registration. The major change which actually shows the change of the government from a trust-based taxation regime to a skeptical-based taxation regime can actually be felt when you actually go through the amendments proposing Rule 21 and Rule 21A. So what is Rule 21? Rule 21 actually provides for scenarios where the registration of a particular taxpayer could be cancelled. So these provides scenarios where the registration could be cancelled. So if I am falling under any of those scenarios, then possibly my registration could be cancelled by the assessing officer. So in general, prior to this amendment, those scenarios were all severe offences. For example, I take a registration but I don't have a place of business, so I am trying to do a bill trading activity, or I am trying to do a bogus transaction, or there is a severe case of anti-profiteering which I have benefited. So the earlier scenarios were all severe offences, nothing to do with minor procedural or minor non-compliances by the taxpayer. But now the government has actually brought in certain scenarios which could actually be minor non-compliances or a procedural lapses, but it could result in the registration of the taxpayer itself being cancelled. So one of the additions to this list is that if a taxpayer avails an input credit in contravention of the provision of Section 16, then his registration could be cancelled. So is it that what the government wants, that if a person has merely contravened the provision of Section 16, his registration itself could be cancelled? For example, if I have taken a credit and the invoice of the vendor is not in line with Rule 36, so there are some deficiencies in the invoice of the vendor, then does it become a case fit for the basis being cancellation of my registration? So is it what is being intended that any non-compliance under Section 16 could actually trigger cancellation or could become a reason for cancellation? So that is something which is not explicitly given. It does not say a severe non-compliance, it just talks about non-compliance of section 16. So that is one of the reasons. Another possible reason which could become a trigger for cancellation of a registration is that if there is going to be mismatch between the turnover and the tax liability reported in form GSTR 1 vis-a-vis your form GSTR 3B which you filed for a particular tax period. So again here, if there is a scenario where due to a reporting error, either my 1 or 3B is incorrect, which is a genuine error and it is not a case where it is being done by a willful intention, then again it becomes a trigger or a reason for cancellation of registration. These kind of scenarios are not serious offences but mere, I would say, procedural or non-compliances, minor non-compliances which should not result to an extent where the crime or the offence committed is totally absurd. The penalty for the crime is not in line with the extent of the offence being committed. So here a small offence could actually result in the registration itself being cancelled. So these changes are actually going in the wrong directions, and one of the other inclusion is that they have introduced a new rule 86B, wherein the extent of utilization of credit has been capped to 99% for certain class of registered persons. So again here this non-compliance of this particular rule 86B could become a scenario for proceeding with cancellation of the registration of the assessee. So somewhere these particular changes may not go well with the industry because it is clearly giving an indication that government has lost the trust in the industry and they are going to have a severe skeptical lens wherein each and every taxpayer would be looked from an angle where they feel that the taxpayer is not a genuine taxpayer. So that is with regard to the changes in Rule 21. Rule 21A, which is suspension of registration. So where any person is actually fitting under Rule 21 or Section 29 of the CGST Act, which is a case where the registration can be cancelled. At the first leg, the registration is suspended under Rule 21A. One of the dangerous amendment which is introduced by this particular notification is that the earlier provision gave an opportunity to the taxpayer to put forth his grounds as to why his registration should not be suspended. So he has an opportunity to go and present before the officer that his grounds are genuine and it does not result in a scenario where his registration is liable for suspension or cancellation. So the opportunity of being heard was provided to the taxpayer, but under the amended provision, the opportunity of taxpayer is actually being removed. So the officer will now have full powers to suspend the registration if he finds that under Rule 21 any of the criterias are being met by the taxpayer. For example, there is a mismatch between GSTR 3B and GSTR 1. The officer has powers now to go and suspend my registration without giving me an opportunity to put forth my case. So my registration would be suspended. Once my registration is suspended, I cannot make any supplies, I cannot file GSTR 3B. Also, they have introduced another provision which says that once your registration is suspended, none of your refund claims under Section 54 will be processed. So again we are looking at a kind of, you can say, tax terrorism, where the government actually wants to use a stick to threaten the taxpayers. A classic example would be Rule 86A, where the officers were provided with a power to block the electronic credit ledger provided they have reasons to believe that input credit has been fraudulently taken and certain specific scenarios were provided. But the department, not understanding the real intention of introduction of this 86A, started blocking the credit ledgers of many taxpayers, including the large taxpayers, and it resulted in a huge issue in the industry where the credit ledger was blocked and the industry had challenges in filing their GST returns because they had accumulated credit in crores and the said credit ledger was blocked. So similar to this 86A, somewhere it gives an indication that this rule 21A could be used adversely by the department, wherein the taxpayers could be taken for a ride and their registrations could be suspended on mere petty grounds or grounds which are not validated in terms of whether it's a serious offense or it is a mere lapse in compliance or a procedure which is followed by the assessee. So here no opportunity provided, straight away your registration is suspended, and after suspension they are giving you a notice. Then against the notice the taxpayer will shall file a reply and then put forth his grounds, and then you are at the mercy of the officer to revoke the suspension and restore your registration. So again, taxpayers will be at the mercy of the tax officers, like what happened in the case of Rule 86A. So these are the changes in Rule 21 and 21A. Some changes have been made in Rule 22, which are to bring the effect of the changes in 21A into 22. 22 talks about cancellation of registration. So again here, just the reference of Rule 21A has been brought in Rule 22. So before closing, I have one small suggestion to the government, is that the mistake or the crime committed by a few cannot become a basis to judge all the taxpayers. Bringing such stringent provisions, such provisions which actually considers each and every taxpayer with a lens that there is a intention to defraud the revenue, would not be the right way to approach the taxpayer, and this could create huge negativity among the taxpayers. So a trust-based approach is what could be ideal, where the mechanism of scrutiny can be determined, or there can be a mechanism by which such scrutiny can be done, but subjecting everybody into these kind of changes would be little harsh. So I only hope that the government listens to the request of the industry, and the industry also makes suitable representation to tone down the harshness which is being brought by this particular notification with regard to the registration, suspension and cancellation. So thank you all.